So we had originally filed a class action suit on behalf of all the arrestees who were appearing before Magistrate Cantrell for first appearance hearings in Orleans Criminal District Court. And the judge issued a declaratory judgment last August because of a kind of a quirk in federal statutory law. If you sue a state judge, you have to first get a declaratory judgment before you could get injunctive relief. In other words, the federal court first has to declare what the constitutional violation is, and then you have to wait and prove that the state judge has continued to violate that declaration, and then you can get an injunction, which is the federal court ordering the state judge to do X, Y, or Z, right? So we had the declaratory relief in August. We found that Magistrate Cantrell had not changed any of his practices, and so in March we moved the federal court to issue an injunction. We then engaged in some lengthy settlement discussions with the magistrate, and he agreed to a consent judgment, which is what we sent to y'all, I guess, and that lays out a pretty strict protocol of how every bail hearing should proceed, and that includes an inquiry into a person's ability to afford money bail, consideration of non-financial alternatives, so whether that would be release on recognizance or release with certain non-financial conditions, and finally, if there's going to be a money bail imposed that a person can't afford, there have to be findings on the record, and it has to be by clear and convincing evidence that there's no other condition that would either ensure that person coming back to court or, safeguard the community. And so I think what we were talking about earlier was, what significance does this have for, the rest of the judicial districts in the state? And I'll say that we have another case currently pending in Lafayette challenging the exact same practices, and that's set for trial in August. But the point being that, most of the jurisdictions that we've seen here in Louisiana don't, really respect constitutional rights when setting bails at first appearance hearings, and particularly in the failure to account for whether a person can afford a money bail that's being set. And so I think that violation is sort of widespread throughout Louisiana.
Do you feel that, this case and then the one in Lafayette could possibly have an impact on jurisdictions across the state?
Yes, I think so. I think that, Judge Fallon, who is the federal court judge here in this case in New Orleans, he had a very persuasive and convincing opinion documenting why these kind of failures at the first appearance hearing violate due process and equal protection. So that's already persuasive authority for other federal courts considering this decision, and it's. I think it's also part of a kind of a larger moment that we're seeing nationwide. I mean, I think people are seeing a lot more stories about bail and pretrial release, and the negative effects that has on society. Whether you're just talking about like from a purely economic standpoint to the costs of detaining all these people who are presumed innocent pre-trial, or just the kind of externalities, the effects of detaining people, whether it's that loss of job or losing housing, and causing rifts in families. There's just a lot of negative effects that I think people across the country are waking up to, and these decisions also sort of recognize that. I think that this case, when we're talking about direct effect, this won't be appealed as it's a consent judgment, and Judge Fallon's original underlying declaratory judgment was not appealed. There were actually two claims in the case originally. One was about these procedures in bail hearings, and the other was about a financial conflict of interest that Magistrate Cantrell and the other judges in the district court have because of a fee that's charged on every bail bond, and so that makes up like a quarter of the court's budget. So there was also a ruling by Judge Fallon that was a violation of due process, that was too much of a conflict of interest for the judges to have when considering whether to set up a bail bond, and that was appealed. That we argued that in May, and we're waiting on a decision from the Fifth Circuit. But in deciding to appeal that, they chose not to appeal this first claim that we're talking about today, the the actual procedures that are used in the bail hearing. And so that's going to stand as good law here for Orleans, indefinitely. The Lafayette case, that will be decided in August, and I'm hopeful and confident that we'll have a similar result there. If that's appealed, then that would go to the Fifth Circuit, and then that would have its own life after that. Can't look that far ahead, but
yeah.
I'm confident that these will be persuasive authority for hopefully other district courts will just voluntarily begin to follow similar protocols. It's not a particularly egregious, a particularly onerous protocol to have to follow. We're really talking about, can you afford the monetary bail without dissent? What are the other alternatives? If there are no other alternatives, are you a person that absolutely has to be detained because I'm concerned that you're not going to come back to court or that you're going to be a danger to the community? And they're kind of like common sense protocols, right? So it would be my hope that rather than having to litigate this in every jurisdiction, that the judicial districts will impose some of these reforms on their own.